Picture a massive construction site. Maybe it's a hydroelectric dam in a remote valley or a sprawling chemical plant right on the edge of a city. It is chaotic.
Oh, absolutely.
You've got cranes swinging overhead, heavy machinery moving earth all over the place, hundreds of workers, and just millions of dollars in materials sitting there. It's this high-stakes environment where everything is meticulously planned, but we all know reality has a way of just punching plans in the face.
Yeah, it definitely does. Construction is it's essentially a battle against entropy.
Right. So imagine something goes wrong. And not just a little wrong, but catastrophically wrong. Say a flash flood washes away the entire foundation. Or a highly specialized turbine gets stolen. Or a wall just collapses overnight.
Which happens more often than you'd think.
Exactly. So once the dust settles and everyone checks that they're actually okay, the panic sets in. And that panic isn't just about the physical damage, it's about the bill. Who actually pays for the wreckage?
That is the multi-million-dollar question. And in the world of major infrastructure, if you don't know the answer to that before the very first shovel hits the dirt, you are basically setting yourself up for bankruptcy.
Which brings us to today's deep dive. We are looking at the disaster plan that's buried inside one of the most widely used construction contracts in the entire world. That is the FIDI 2017 Conditions of Contract for EPC Turnkey Projects. And specifically, we are zooming in on Clause 17.
Clause 17, care of the works and indemnities.
It sounds so gentle, doesn't it? Care of the works, like we're tending a nice garden or babysitting. But reading through the source material, it feels way more like a prenup for a very, very volatile marriage.
Huh. That is a surprisingly accurate description. Clause 17 is essentially the battleground for liability. It defines exactly who is holding the bag, or as you might say, the hot potato, when things break, when they disappear, or when they injure someone.
I love that hot potato analogy because in this specific game, the potato is made of radioactive debt. And the whole mission of this deep dive is for you, the listener, to figure out exactly who is holding that potato and when. Because as I understand it, this isn't just a simple rule of you break it, you buy it.
No, that would be far too simple. This is really all about risk allocation. The core philosophy here is that risk should be borne by the party who is best able to actually control it.
Okay.
So in a turnkey project, which is where the contractor is designing and building absolutely everything, they usually carry the bulk of that risk. But Clause 17 adds these really fascinating layers of nuance, specifically regarding timelines and triggers.
Okay, let's actually map out that timeline. Let's say I'm the contractor, I've signed the deal, I've got my hard hat on. When exactly does the clock start on my liability?
The literal moment the clock strikes the commencement date. From that exact second, you, the contractor, take full responsibility for the care of the works, the goods, and all the contractor's documents. You are the sole guardian of the site.
So if I'm building a power plant, and on day 2, a bunch of copper wiring gets stolen, or a freak storm knocks over a temporary fence, that's entirely on me.
It is entirely on you. You have to rectify any loss or damage at your own risk and your own cost. The employer, the client, they effectively wash their hands of the physical safety of the site during this whole period.
Okay, that feels pretty standard. I mean, I'm the one with the keys to the gate, so I should be the one watching the store.
Yeah.
But when do I get to stop worrying? Is it when I lay the final brick?
Not necessarily. The responsibility generally stays with you until the date of completion of the works. But this introduces one of the most critical concepts in the entire FIDI contract, and that is the taking over certificate.
The golden ticket.
It really is the golden ticket. The taking over certificate is the specific trigger that shifts the risk. Once that certificate is issued, or in some cases deemed to be issued, the responsibility for the care of the works officially passes to the employer. They take the hot potato.
So that's the finish line. I get the certificate, I pop the champagne, I delete the site manager's phone number, and I'm completely free.
Well, see, that's exactly where people get caught out. You're mostly free. But there is a hidden trap door. Even after the employer takes over the site, the contractor is still responsible for any outstanding work.
Outstanding work? Like, you mean the punch list? Just the little touch-ups?
Correct. If you have a list of minor defects to fix, or small works to complete after that official completion date, you still own the risk for that specific work.
Wow, that sounds like a total nightmare for liability.
Yeah.
Because imagine the employer has moved in, right? They're running the plant, doing their thing, but I'm still standing in the corner fixing a valve. If that valve blows up, do we just get into a massive fight about whether it was my outstanding work or their daily operation that caused it?
Oh, you almost certainly do. It creates this huge gray area where two different parties are occupying the exact same space, but with totally different liability profiles. If loss or damage happens during that period and it stems from your outstanding work, you are still on the hook to fix it out of your own pocket.
Okay, so the baseline rule is clear. Contractor pays for everything until the official handover and then pays for their own leftovers after the handover. But surely there have to be exceptions to this. What if something happens that is just totally, fundamentally out of my control?
There are absolutely exceptions. This is what we call the not my fault defense, and you find it in subclause 17.2. These are very specific scenarios where the contractor can basically stand amidst the smoking rubble and say, hey, not my problem.
Let's walk through these because reading the source text, some of them seem a bit, well, open to interpretation. And the first one listed is interference.
Right. It says unavoidable result of the works. This covers things like unavoidable interference with rights of way, light, air, or water.
Okay, break that down for me. Give me a real-world example of interference.
Imagine you are hired to build a massive hydroelectric dam. By definition, a dam blocks water. If that blockage stops water from reaching a farmer downstream and that farmer turns around and sues for lost crops, that is interference.
And I, as the contractor who built the dam, am not liable for that lawsuit.
Only if it was an unavoidable result of the works. If the contract literally said, build a dam right here, and you built it there, the interference is the employer's risk. They chose the site. They chose the project.
But wait, what if I built the dam using a method that was unnecessarily messy? Like, say I just dumped a bunch of extra rubble in the river that didn't actually need to be there, and that specific rubble caused the blockage.
Ah, then you are right back on the hook. That's the key distinction. Is the damage caused by what was built, which is the employer's risk, or how it was built, which is the contractor's risk?
That makes total sense. It rewards competence but protects the contractor from the project's inherent nature. What about the next exception? It's use or occupation by the employer.
This is essentially the early use rule, and it's incredibly common. The project isn't entirely finished yet, but the employer gets impatient. They want to start moving desks into the office block, or maybe running tests on one specific part of the factory floor.
Right, and if they move in early and scratch up the new floors, obviously I don't pay for that. But what if they move in and their actual presence prevents me from securing the site properly for the night, and then something gets broken?
Then the risk has already shifted to them for that specific part of the works. The contract essentially says, look, if you want to use it before it's officially done, you take responsibility for it. You cannot blame the builder for damage in a room that you're already occupying.
Fair enough. Now here's the one exception I really struggle with. Design errors. This is an EPC contract, a turnkey project. Isn't the entire point of a turnkey project that I, the contractor, do all the design? How could I possibly blame the employer for a design error?
You're right. Normally, the contractor owns the entire design in these setups. But sometimes the employer mandates very specific things in their initial requirements. They might say, you must use this specific type of patented turbine from this one specific vendor. Or you must stick exactly to this architectural layout.
So if their mandatory turbine just explodes on day 3,
Then you aren't liable. The clause explicitly excludes liability for any fault, error, defect, or omission in any element of the design that was provided by the employer.
it's basically the I told you so clause.
In a way, yeah, it protects you from their bad ideas. And finally, we have the really heavy hitters in this list, the forces of nature.
Acts of God.
Yes, but with a surprisingly high bar. These events have to be unforeseeable or something that an experienced contractor couldn't reasonably have prevented.
So if I'm building a beachfront resort in Florida and a hurricane hits, is that unforeseeable?
Probably not. An experienced contractor knows that Florida gets hurricanes and should secure the site accordingly. But if a massive tsunami hits a construction site in Nebraska, that's unforeseeable.
And we should also mention exceptional events here too, right? Like subclause 18.1 stuff.
Yes, exactly. Things like war, rebellion, terrorism. If a war breaks out and destroys your site, that falls under the not my fault defense too.
Okay, so let's say one of these exclusion events happens. The totally unforeseeable tsunami of Nebraska wipes out my site. I don't have to pay to fix it, but the site still needs to be fixed, right? We can't just leave a giant crater in the ground.
Correct. The employer will instruct you to fix it. But here's the crucial mechanism. Because it was an exclusion event, this repair work is officially treated as a variation.
Which means I actually get paid for the cleanup.
You get an extension of time in EOT, So you aren't heavily penalized for delivering the project late, and you get cost plus profit.
Wait, hold on a second. Cost plus profit, I get to make a profit on fixing a total disaster.
You do.
That feels really generous. Why should I profit from a catastrophe?
Well, you have to think about it from a purely business perspective. You are a construction company. You're not a charity. If you have to abruptly divert your workforce, your heavy equipment, and all your management focus to rebuild something you've already finished, through absolutely no fault of your own, you are losing the opportunity to make money on other projects. The contract just recognizes that your time and resources have intrinsic value.
That's a really solid point. It basically keeps the contractor from going bankrupt, which honestly is in the employer's best interest too. They ultimately need the building finished.
Exactly. It ensures the stability of the entire project.
So that pretty much covers the physical world: bricks, mortar, floods, and dams. But in the modern construction world, sometimes the most expensive thing you can break isn't physical at all. It's an idea.
Which moves us right into subclause 17.3, intellectual and industrial property rights.
This feels like a totally different gear. We're suddenly talking about patents, copyrights, trademarks, trade secrets.
It is a different gear, but the financial risk is just as high, if not higher. Imagine you build this state-of-the-art waste processing plant. It's running perfectly. Then, 6 months down the line, you get a formal letter from a massive tech company saying, hey, that chemical process you're using, we patented that. Pay us $50 million.
Ouch. So that's considered a claim under this clause.
It is. And before we even figure out who pays that $50 million, we have to talk about the 28-day rule.
I saw this in the text. It seems incredibly strict.
It is brutal. The clause plainly says that whenever a party receives a claim, like that lawsuit letter, they must give notice to the other party within 28 days.
And if they don't, say they wait 29 days.
Then the first party shall be deemed to have waived any right to indemnity.
Wow. So even if I am 100% in the right and the other guy totally should be paying this massive fine, if I just forget to forward the email for a month, I end up paying the entire $50 million myself.
Yes, it is a strict use it or lose it mechanism.
Why on earth is it so harsh? That just feels like a legal technicality designed to trap people.
It feels that way, sure, but there's an underlying logic. It prevents sandbagging.
Sandbagging.
Yeah. Imagine the employer gets sued for patent infringement. They know for a fact it's the contractor's fault. But instead of telling the contractor immediately, they just let the lawsuit drag on. Legal fees pile up, maybe they make a few really bad strategic decisions in court, and then, years later, they hand the massive bill to the contractor.
Ah, I see. The contractor is completely denied the chance to defend themselves. Or maybe just settle it early and cheaply.
Exactly. The 28-day rule forces immediate transparency. It essentially says, if you want me to cover this risk, you have to tell me about it the very moment it happens.
That makes a lot of sense. It's about not letting the problem just fester in the dark. So assuming everyone actually sends their emails on time, who actually pays for the IP infringement?
It splits based on origin, very similar to the physical damage rules. The employer indemnifies the contractor if the infringement was an unavoidable result of complying with the employer's requirements.
The old "I built what you told me to build" defense.
Right. Or if the employer used the works for a purpose that wasn't actually indicated in the contract.
Like using a civilian drone factory to suddenly manufacture military weapons.
Precisely. If that unapproved pivot triggers a patent lawsuit, that's entirely on the employer. On the flip side, the contractor indemnifies the employer if the infringement comes from the contractor's execution of the works or their use of contractor's equipment.
So if I decided to use a highly specific type of piling rig that happens to infringe on someone's patent, that's my problem.
Yes. And typically, the party who is indemnifying, the one actually paying the bill, takes over the legal defense, they run the negotiations, they hire the lawyers, and they call the shots.
Which is fair. If I'm writing the check, I want to control the defense strategy. Now, we really need to talk about the darkest part of Clause 17. We've covered broken walls and we've covered stolen ideas. Now we have to talk about broken people.
Subclauses 17.4 and 17.5. Bodily injury, sickness, disease, death, and damage to physical property.
This is obviously where the numbers can get astronomical, and the human cost is just tragic.
Yeah.
How does FIDI actually handle this level of risk?
Subclause 17.4 covers indemnities by contractor. The contractor basically holds the employer harmless against claims from third parties. So if your crane accidentally swings out into the street and crushes a parked car, or worse, injures a pedestrian, you, the contractor, cover that completely.
That seems pretty standard for any business, really. If my daily operations hurt someone, I pay.
It is standard. But there is a massive addition in 17.4 regarding design that we really need to highlight. The contractor also indemnifies the employer for any acts, errors, or omissions in the design that result in the works not being fit for the purpose.
Fit for purpose. Those three words strike absolute fear into the hearts of contractors everywhere.
And they really should. In an EPC contract, fit for purpose is a staggeringly high bar. It means it's not enough to just follow the local building codes or use high-quality materials. If you are building a water treatment plant and you finish it on time and it looks beautiful, but it doesn't actually treat the water to the specific standard required by the client, you are liable.
Even if I wasn't technically negligent, even if I tried my absolute best and followed the industry standard.
It simply doesn't matter. If it's not fit for the specific purpose defined in the contract, you have failed. And you indemnify the employer against that failure. It's an absolute obligation.
That is a tremendously heavy burden. And so subclause 17.5 is just the reverse, the employer indemnifying the contractor.
Yes. The employer holds the contractor harmless for bodily injury or property damage if it's directly caused by the employer's negligence.
Which, again, seems perfectly fair.
It also loops back to those exclusion events we discussed earlier. Remember the farmer with the dried-up river?
Right, the interference case from the dam.
Exactly. If the dam blocks the river and ruins the farmer's livelihood, the employer indemnifies the contractor against the farmer's financial claim, because that damage was an unavoidable result of the employer's overall project.
Okay, so we have these two neat buckets. Contractor pays for their mess, employer pays for their mess. But life is rarely that clean, is it?
Never.
Real disasters are usually this terrible comedy of errors. Like the contractor left a gate open, but the employer's security guard was asleep on the job, and the initial design was slightly flawed anyway. Who pays then?
This brings us to a really elegant part of the contract. Subclause 17.6, shared indemnities.
The let's be reasonable clause.
It introduces the concept of proportional liability. It acknowledges that fault isn't always binary. It's not a simple on or off switch. It's a dimmer switch.
How does the actual math work in those situations?
The contract says liability shall be reduced proportionately. So let's say the contractor is technically liable for a major loss on site. But upon a deep investigation, it turns out that one of the employer's excluded events, like a specific design error the employer insisted on using, contributed 40% to the ultimate failure.
So I only pay 60% as the final bill.
Exactly. And it works both ways. If the employer is indemnifying the contractor for something, but the contractor's own negligence made the situation significantly worse, the employer pays less.
That feels like the most realistic part of the entire document. It forces everyone involved to own their specific slice of the disaster.
It does. It prevents someone from getting a totally free ride just because the other party was mostly at fault.
So we've unpacked a lot of dense material here today. We've gone all the way from the first shovel hitting the ground to the final handover. We've dodged unforeseeable hurricanes, we've fought off patent trolls, and debated the exact quality of water treatment plants.
It's definitely a journey through the worst-case scenarios.
When you step back and look at Clause 17 as a complete whole, what is the big takeaway for you? Why does this matter to a listener who isn't a construction lawyer?
I think the biggest takeaway is that a massive contract like FIDI isn't just a giant list of rules designed to beat people up with. It's actually a roadmap for fairness in a highly chaotic world.
How so?
Well, construction is inherently fundamentally risky. You are imposing human order on the natural world. Clause 17 forces the parties to sit down and ask a very difficult question right up front. Who is best placed to manage this specific risk?
Right. The contractor manages the site safety and the building method. The employer manages the land selection and the ultimate purpose.
Exactly. And when you perfectly align the risk with the person who actually has the power to control it, you end up with a safer, much more efficient project. It stops being a legal game of gotcha and starts being an actual partnership.
Unless you miss that 28-day deadline.
Unless you miss the deadline, then all bets are entirely off.
That is the one thought I just cannot get out of my head. We talk so much about billion-dollar concrete structures, massive cranes, and deeply complex engineering feats. But the thing that could actually bankrupt your entire company isn't a collapsed retaining wall. It's an email sitting in your draft folder.
It's the sheer administrative burden. The contract rewards administrative vigilance just as much as it rewards engineering skill. You have to be a brilliant builder, yes, but you also have to be a flawless bureaucrat.
The most expensive email you never actually sent. Well, on that slightly terrifying note, We're going to wrap up this deep dive into the architecture of responsibility. If you're out there pouring concrete or if you're just the one signing the checks, remember, read the fine print, check your insurance coverage.
And please set a calendar reminder for those legal notices.
Absolutely do that.
If you're interested in the templates, please visit our shop. The link is in the description.
Thanks for watching. Please subscribe and see next time.